Per pretrial, he's tested positive.
All right, pause right here, because this case is about to go off the rails fast. We're starting with a pretrial hearing, which means this guy is already on thin ice. When a judge is reviewing bond compliance, attitude matters just as much as actions. And trust me, this judge is already irritated.
I think they described his behavior as
Threatening.
Well, I didn't get threatening, but
I got threatening.
Okay.
And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond, and now goes with you.
if I can, Judge, I don't believe there has been actually any evidence presented to warrant a bond revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge.
Don't
there was
speak.
no threat of harm or anything like that. It was just more so attitude. He was making people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting anyone in danger, threatening danger, anything of that sort.
This is where I want.
That right there? That's a judicial warning shot. When a judge says they'll light you up like a Christmas tree, that's not courtroom theatrics. That's a clear signal. One more slip and you're going into custody. Judges expect humility on bond, not bravado. Question for you. Do you think the judge has already decided this guy's fate?
An open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to your point. Do you have a preference on the reset date, Judge?
Tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I will add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have some magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did come with them.
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, B-L-E-D.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs, and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
Here's the legal nuance a lot of people miss. Even though marijuana laws vary, bond conditions override everything. Medical card? Delta 8? THC seltzers? None of that matters if the judge says no THC. Bond conditions are absolute, and violating them is one of the fastest ways back to jail.
I also give my spiel about THC seltzers that I could buy at Specs. that have no alcohol but have THC in them?
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need, but if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry. You're right. You said
Then
2
I'll
weeks.
test him back and we'll see.
This is where things get serious. The court isn't just looking at drug use anymore, they're looking at a pattern. Multiple cases, prior assault, probation. This is what judges call escalating risk. At this point, the question isn't if consequences are coming, it's how severe they'll be.
Do you
But
want
by then it'll be sufficient benefit that
Yes,
there's
Judge.
just no argument.
do you want him 2 weeks from today testing on that date?
Yeah.
Okay. We'll do. Thank you, Judge.
For sure, Nate. And thank you.
Ordered you not to use. We're now working. When did we order him not to use? What was the day?
On this case that I'm on.
His case has been open since February. The end of February.
February 26th, Your Honor.
Say it again?
February 26th. of this
Yeah,
year.
February 26th. We're now April 16th. It's been 51 days.
Yeah.
I'm putting you in jail. I told you not to use. You're continuing to use.
Maybe.
Okay?
And I know how the court generally feels about the prescriptions for the marijuana, but he does have a valid prescription.
Nevertheless, I told him not to use.
He's gainfully employed judge, which when we came here previously, you had ordered him to get a job, which he did. And of course, he's brand new at the job. And if he goes into custody, he's most certain to lose that job.
Michael, I don't want him to use. What else am I supposed to do? I don't care that you're now working your second criminal case within the last year, you know? You have an assault from 23, now you've got a theft.
One more opportunity, Judge.
How long am I supposed to give him, Malcolm? Another 30 days for him to just continue smoking weed and just...
Test him in 2 weeks, Judge? Or even, I don't know if next Thursday will be too soon for the levels to go down. I'm not really.
Do you have levels now?
No, not at this time, since it was a rapid test that needs to be confirmed at the lab, so.
If you want me to give you the benefit of the doubt of next Thursday, I will do it. You must be here Thursday. If you test positive for weed,
Did you catch that? The judge is basically saying, I don't care how clear I make this. I've said it every way possible. When a judge resorts to sarcasm, that's courtroom code for patience is gone. Comment below, should judges be this blunt, or does this guy deserve exactly this energy?
it's not going to go well for you. I've harped on it over and over and over.
Yes, sir.
Judge, and I don't know the science, is what currently in his system, would it be gone by next Thursday? Or would it still be in his system and he tests
If he
positive?
continues to smoke, then no. But by then it'll be 2.5 months. So if it's still in his system, that tells me that he's continued to smoke weed while he's on bond. You know,
Yeah,
there's only two things. It's either in your system or it's out of your system.
I don't smoke, so I got THC tinctures.
What's
I
that?
don't smoke flower. It's not a flower.
You're not supposed to use anything that has THC in it that could cause you to test positive. You know exactly what you're putting into your body. You know exactly what I've ordered you not to do. We'll put you on for this Thursday. I don't know what else to tell you. I mean, you want hieroglyphics? Perhaps Mandarin? I don't know what else. I'm speaking English here. I've told you what you can and can't do. That's it. I'm going to give you the benefit because of Michael that you got until next Thursday. If you continue to test positive, it's just not going to go well. All right?
Yeah,
See you
sure.
Thursday.
Thank you, Judge.
All right.
Guys, I see he's got a felony warrant.
No, there wasn't one. I checked about an hour ago. Okay.
He's on probation for credit card abuse, picks up this assault, and I'm looking now, there's a felony warrant for an assault on a security officer, assault of a peace officer.
That case has already been opened, and he's been
I
going.
remember it being open. I remember that we've had issues with this, but maybe I'm wrong. I don't know. Regardless, I mean, we're going to do this now. It's just that if there's an open warrant, I'm going to have to take you into custody. I don't know.
And here's the plot twist no one saw coming. A warrant drops mid-hearing. This is every defendant's nightmare. 1 minute you're talking plea deals, the next minute the system catches up to you. This is why bond violations are dangerous. Once the court loses trust, everything unravels fast.
It appears to be so, but the computer's been wrong before. Yeah. Take your time. No rush. Mr. Miller, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 4 days in jail with credit for the 4 days that you've done. You need to understand that by pleading guilty to this offense, there are consequences that may arise. If you're on probation or parole, this can be used against you, which would result in further confinement. Do you understand? Do you still want to go forward with this?
We'd like to see you check with the warrant. I mean, if he's going to be going in, and we may want to hold off on the plea today.
Okay, it's up to you here.
Who is issued to the judge?
Hmm?
Who is issued to the sworn himself?
It's weird because when I looked earlier this morning, because I knew he had bond violations here. The reason you're here now is because you have bond violations, right? And when I looked earlier, there was no warrant.
Yeah.
And when I just pulled it up now to look, a warrant has been issued. They issued a warrant 8 minutes ago.
Okay.
And we does this give a reason why?
Bond condition violation.
There you go.
Okay.
Mr. Miller, when you're on bond, there are conditions that you must follow. And when you don't, there are consequences.
As of right this moment, it is not current, it is sitting on the judge's thing to be signed.
He's saying it's.
They issued it by the clerks, but it hasn't been signed, so.
That's where I'm seeing it, but it is not showing up in Jim's as of this.
I need to know what you want to do. Do you want to go forward with this plea, or do you want
Will
to?
he be going into custody because he hasn't been signed yet?
He's got bond violations with me. He's on probation, picks up a case. Now he picks up a felony case. He's got bond violations with me.
Yes, but if we do the plea in here, the bond violations are
Yeah, if you do the plea, then you do the plea. It's up to you guys.
signed
Yeah,
yet.
I'm,
Okay.
if it's not signed, no, because we can't do anything to.
Well, I will just verify, just to make sure, if he can be able to, I will just call in.
I would just be, Mr. Miller, see, you're skirting a very thin line, man. You know, you tell me what you want to do.
Well, if he can leave today, I think that's what you'd like to do is take the.
If we do the plea and she hasn't signed it, I have nothing to hold him. But you need to understand that it may at some point happen. So
He does have court for this case, that the felony case next week. So that would give him some time to get something set up with a bondsman and get something worked out.
I don't know. So do you still want to go through with this, Mr. Miller? So yes? Okay. So you were charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 4 days in jail, credit for the 4 days that you've done. Understand that, like I told you, there are a lot of rights that you're giving up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you plead guilty, you can never take this back. will go on your record and it's going to be there forever. From now on, you're facing a minimum of 90 days in jail. Do you understand? If you're on probation or parole, you also need to understand that by pleading guilty to this, they can revoke that probation or parole and it can result in further confinement. Do you understand? Do you still want to do this? Okay. How do you plead to the offensive assault, bodily injury, guilty or not guilty? I'm going to find you guilty. I will follow the agreement, sentence you to 4 days in jail. I will give you credit for the 4 days that you've done. I will roll your court costs so you won't know anything. And good luck to you, sir.